right. Welcome everyone to on the Ray Law International channel for our next live stream. My name is Anthony Ray, and we have a very important and interesting topic for you guys today. Before we get into our topic today, I did want to go over some updates. Now, when I was preparing for this, we're really focused on employers and I-9s. However, so much has happened over the past 30 days that I feel it is so important for us to give you some highlights. Now, if you are out there and you're trying to navigate the immigration process without an immigration attorney, please, please, please rethink that. Reach out to us. Call us today so that we can help. Things are drastically different. They're changing every week. And without the proper guidance, you're not going to get the immigration benefit. You're going to lose out on business. You're going to have your key employee blocked or barred from the United States for a long period of time, which you don't want to do. You want to make sure that everything is done properly, and that's why you need to reach out to us. So, how's everyone doing out there? If you're listening, go ahead, tell us where you're listening to us from, whether that's in the U.S., let us know the state you're listening to us from, or whether you're outside, let us know the country. We're always glad and thankful that you guys can join us. And I mean, you are definitely going to get something from today's discussion. There is just so much going on. If you have questions, please put them in the comments. We'll respond to them as we go through the live stream, or if need be, we can always respond afterwards. But please, we get so many questions every day. People are lost. The information on Google is not accurate and often doesn't apply to your particular case, whether that's employment, the employer, um, just so many examples I can give you this week where we were speaking with an employer. You know, the employers are abroad, they're in the US, but the foreign headquarters, they really don't understand US immigration, let alone, Canadian or Mexican laws. And what they're doing is just going to cause them problems and their employees problems. They're not going to have the employees where they need them to be and to get the results they need. So it's so important that you talk with us, get the consultation. It's going to save you thousands and thousands of dollars by just sitting down and consulting with us and making sure that we have answered all your questions. You know exactly which path you're going. And when your employees get challenged or ask questions, they're going to know exactly how to respond, why they're lawfully authorized to work in the US, and why what they're doing is legal. They're going to have the basis for that. They're going to have that support and ammunition in order to discuss that with CBP when questioned at the port of entry. So, that being said, what else is going on? So much has happened since the new administration has taken over. We're continuing to see these many changes. I'm going to talk about H-1Bs shortly as well and how that is going to be impacted as well. So first and foremost, the first thing I wanted to highlight on our updates is the Department of State. Interviews are back at the U.S. embassies. I think we're going to need a lot more employees at the U.S. embassies around the world to handle the increased volume. The current status quo for doing interviews on non-immigrant visas is your initial interview. You go for your initial application for your non-immigrant interview. You go in for an interview. You submit everything. They question you. They ask you. However, if you are filing an extension or renewal for the same position, same company, at the same place, there's no real changes, you just need a new visa stamp, then you don't need to go through the interview. They have a mail-in process. Now, this process has worked beautiful for years. There's really no reason for the change. I don't know why, what justification, but there is no problem with the current system. As my mother-in-law always say, if it's not broke, don't, I'm not going to replace it. There's no need to replace it. You want to keep things moving forward efficiently. This new mandate, which is going to take effect, I believe it is September 1st or August 1st, coming up real soon. I believe I believe it's going to be September 1st. Um, so what's going to happen is you're going to see increased delays at the US embassies. It's just going to be longer and more unbearable to come to the United States. And because of the limited resources by the Department of State, they're going to have to prioritize which visa categories they're going to focus on first. Are we going to see delays in the visitors visas, the B1, B2s, or are we going to see delays in these employment-based interviews, such as the E's, H's, the J's, the L's, and O's? So if you are applying for one of these visa categories, go ahead and put that in the chat. Let us know. How long are you waiting for your visa interview? And I encourage you, if you need to make a visa interview, do it now. Don't wait until after September and this new rule goes into place. Another change about this rule, which is huge, is that um, applicants who are under the age of 14 and over the age of 79 now need to go do an interview. It's crazy. Previously, for children under 14, they just needed to submit their passports and everything. Their parents were sufficient. Now we've got to take the newborn who's 1 month old, you know, take the car. We usually use car seats here in the US, but many countries you don't have that. Take the stroller or whatever you carry your child in, and you need to take them to the interview to be interviewed. Yes, our government is now interviewing children under 14. What are they going to ask them? I don't know. But this is the new mandate. Additionally, those individuals who are 79 or older, those individuals also need to go. So, um, hopefully your parent or elder is not hospitalized or whatnot. They're going to need to go to the interview. Now, a couple other things about this is I think for the interview waivers for B1, B2s or border crossing, you can apply 12 months prior to the visa's expiration, which is a limitation. Before you could just apply anytime. Let's see, any others? They're going to force people to apply in the countries of their nationality or residence, no third-party country. And they're looking for people who have never been refused a visa in the past. This is one thing I always like to tell people when I consult with them and speak with them is when you apply for a visa, it's not like you get multiple choice chances. It's really a one and done deal. If you get denied the first time, you're always going to be denied, in spite of the fact that the officer says, oh, you could just file again. And that builds this false pretense that, yeah, if I file again, I'm going to get approved the second time. No, it's the rule of insanity, doing the same thing over and over again and getting the same results. That's what you're going to get with the State Department after you get a denial. Therefore, it's so critical that on the initial application, you have the help of an attorney. We guide you, talk about all the things you need to pay attention to and document and what to say in the interview, but more importantly, to avoid the pitfalls. Things that you think are just normal are not normal here in the United States. So it's so critical when you go to interviews that you get it approved on the first time. Once it's denied, it's essentially done unless you get into a very different category that you're qualified for. An example of that might be, for example, you apply for a B1, B2 visa stamp. They believe you don't have sufficient ties to your home country. You get denied, and then you apply for a different category, such as an H1B or an L or an E. In that scenario, you're going to get approved for the H, E, or L. However, if you apply for the B1, B2 again, you're going to get the same results, and you're going to ask why. And unfortunately, they don't have to give you an answer, and they don't. Um, Whenever you go into the interview, try to ask the officer the reason for denial and make sure you write down as much of those details as possible because an attorney like me and others need that information to evaluate what went wrong, what's the next approach, and how we're going to move forward in your case. So, from this whole visa thing, I know we spent about 10 minutes on this, but it's so critical because it's coming up right away. Longer visa, we can expect longer visa appointments, backlogs. Um, Everyone's got to go in person. You cannot take your attorney with you. However, you can hire an attorney to prepare, drill and rehearse, figure out what to expect so that you don't go in there blind or nervous. You're going to be well prepared. And you cannot shop around to consulates. Okay. For here in the northern border, you can go to the tunnel to come into the United States from Canada. And if you get denied there, you try to go to the bridge or one of the bridges now, and you're going to get the same result because you're always in the computer. Likewise, abroad, you can go to a US embassy in Germany and then try France. You're going to get the same results because one, you need to disclose that you were denied, and if you don't do that, that's misrepresentation. You could be barred for the U.S. from the U.S. for many, many years. But even if you don't disclose it, you're going to be in the system. Okay, so keep that in mind. The next reminder is regarding I-94s. Always, always, always verify and check your I-94. All too often, you just come in the United States, you stamp, you believe our government knows what they're doing, you believe that they don't make mistakes, but they do, and they don't know always what they're doing. So check to make sure you got the right visa category. The best way to do this is to make sure you check the website. Our I-94s or the arrival departure cards are all electronical on the ICE website. So if you don't know where that is, reach out to us. If I get a chance, I'll put in the link so that everyone has it. We can go ahead and do that now. I always have it there. You can check your status and make sure that everything on your I-94 is correct. Now, if you are with a large organization and you have hundreds and hundreds of people to verify, it is imperative for your foreign nationals that you, in fact, do check their I-94s each time they enter. I know it's something that people don't have the time for, but this could really impact their status. And more so, there's less discretion nowadays with immigration. So if someone makes mistakes, there's an oversight, you can't correct it. These people are going to be impacted by US immigration laws or the failure to follow them for their entire life. Doesn't matter if they're 80 or 90 and it's been 50 years since the incident occurred, they're going to be impacted by that. So please, 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 make sure your HR team knows what to do. They check those I-94, and there's more communication between the foreign national employees. Make it a policy, make it a procedure that they always issue you I-94s upon every entry. That way, if they screw up, the company's still going to be at a disadvantage because they're losing a key employee, but at least the person needs to take responsibility and they'll have to admit that they didn't inform their HR. All right. Our next update. The next update is regarding the Ninth Circuit, backs limits on ICE immigration sweeps in LA. This is very important because the current administration is looking to expand these actions, not just in California and in DC, but beyond. So this is an ongoing issue or challenge within the US where our government is creating reasons for sending out the National Guard and our US military against its own citizens in order to show force, do something, I don't know, but we already have police that takes care of law enforcement, so there's really no need for their assistance. Now, they do say that ICE needs additional support, but a lot of what we see is not just supporting ICE, they're doing other things, supporting police and things like that. So um, be mindful of that. Ninth Circuit has limited that. I'm sure it'll be appealed up to the Supreme Court, and we'll have to wait to see what the Supreme Court says. Next, First Circuit is doubtful about Trump's stance on birthright citizenship. If you're not familiar or you haven't heard, birthright citizenship, that's where if anybody is born in the US or one of its territories, then they are automatically become a US citizen. Doesn't matter whether they're here, whether they entered legally or not, doesn't matter their non-immigrant status or not, they are just US citizens. So the current administration is challenging that for whatever reason. I don't know. You know, it there's some legal arguments that they're making that really doesn't make sense. We've never had a problem with birthright citizenship. It's just certain people want to get rid of it, and I think they're taking those actions to do that. Right now, the First Circuit is doubtful. We don't have a final decision. However, when we do, we can expect that to be going directly to the Supreme Court for a final up or down. Finally, um, um, a judge has suspended the expedited removal of parolees. Basically, there are certain individuals who were paroled into the US, think Venezuela and many others, who were granted authorization to be here, were invited to come here and work and reside because of the situation in their home country. While the administration is trying to expedite them with expedite removal. And what that means is they don't have to go through any hearing, there's no due process. These individuals are just picked up, put in detention, put on a plane, and sent back. And that's it. And the judge has put a halt on that and trying to make sure that these foreign nationals are granted due process. Now, one of the main things that U.S. citizens, I and many others need to be concerned about is the deterioration of due process for foreign nationals is just the next step of the violation of due process for us U.S. citizens. And we already see that happening throughout the U.S., where U.S. citizens are being detained without probable cause, and the courts and the system is not protecting us. And that's of greater concern as we tend to move further away from this democracy. It is incumbent upon U.S. citizens to protest, speak up, and do everything in our power to make sure that our constitutional rights are protected. Okay, this isn't even about immigration, it's just about our constitutional rights. So there's a lot of updates. One more update before we get to our topic on I-9s. This is a big one, and it impacts a lot of our clients. It impacts pretty much every foreign national student coming here to work, and that's H-1Bs. H-1Bs, if you're not familiar, is a work authorization category for professionals. This allows, and when you think about professional things, so think of positions that require a four-year degree. Engineers, accountants, doctors, lawyers, computer systems analysts, and the list goes on and on and on. Now, H-1Bs, for whatever reason, only 85,000 have always been under attack. Instead of forcing our U.S. citizen children to go into STEM fields like other countries are, we much rather attack 85,000 jobs that are granted H-1Bs, which is minuscule to the larger part of our whole economy. Okay. I think the better approach, this is just my opinion, is our schools, our education system should force people to go into the STEM field more so. Now, does this sound democratic? Does it sound American? No, but as to this particular issue, we don't have enough people going into the STEM fields. Okay, we just don't. And the more US citizens go into that, the better it will be. So be a doctor, be a lawyer. I'm sorry, not a lawyer, be a doctor, be an engineer, get into cybersecurity, There's so many STEM fields to get into. So force or direct your children, if you're against H-1Bs, make sure your kids are in STEM. Make sure they get jobs in the STEM field. Okay. Um, and the difference is many other cultures are getting, focusing their children, such as India and others, on jobs that are in the STEM field and are jobs of the future instead of jobs that may be replaced by AI, which we're going to be seeing, which we are seeing, which we're seeing right now. But back to the H-1B. So, what are we expecting? A little bit of what we saw before. The administration is going to propose a rule that's going to change the selection process for the H-1B. And most likely, what they tried to do before is they're going to give it to the individuals with the highest incomes. Okay. What does that mean for everybody else? For small employers, for recent undergraduate graduates, the H-1B is going to be very challenging or next to impossible to obtain because no one's going to pay a new grad, you know, whether that's in the STEM field or not. Usually, they're not going to pay them 200,000 because what's going to happen, we're going to go to California, New York, and where wages are the highest, and they're going to be focused on those individuals. Now, the articles that you read out there, such as in Forbes, they talk about the 4 levels of the wages set by the Department of Labor. Now, these wages set by the Department of Labor are ridiculously high. They are not representative of real life, what US citizens get paid. They're far and above. So oftentimes people argue that H-1Bs are paid less. That is misleading. And the problem is that people just read or listen to the news clip on ABC, CNN, because they cherry pick a few cases, but don't look at the total or what's real. So if we have a small employer who needs to hire an accountant and they've got to pay a level 3 wage, for example, let's say in California, they're looking to pay level 3 maybe 120,000 for a fresh grad who knows nothing. You know, those are things that normally, they may pay them 70, 80, 90,000, but they're definitely not going to pay them 120 or 130. So these are the challenges even employers who use the H-1B are faced with every day. Can they pay the prevailing wage? That prevailing wage is set by the Department of Labor unless there's some union contract or some other alternative wage source that we want to use. So H-1Bs, we expect that change, expect that before the next lottery or selection process in March of 2026. Again, those who are not familiar, there's a regular 65,000 and then an additional 20,000. The administration is looking to give those to the upper echelon salary-wise. And what that means is large companies such as the big tech firms and major companies are going to be primed to benefit from those. Whereas the majority of all those other companies, are just won't have the resources or bandwidth to pay someone at that high salary. All right. That is the update. I mean, there's a lot more. I wish I could share, hours of the stories that we talk about and work with people. People are scared. People don't know what to do. The government has made it challenging, if not difficult, for people to do anything positive or even to do it the right way. And we are really, really just trying to see how to best navigate our clients. Even if they are deported, how are we going to get them back in the quickest? So a lot of challenges. You need an attorney to walk through the process. I've been talking about our updates for some times. And let's see. Yeah, yes. Jiyoung, it is a lot of updates. I mean, I probably didn't even get through half of them. There's so much more out there. It's challenging, but you want to place that burden on an immigration attorney. You don't want to, bear it yourself. Just quick story before we talk about I-9s. Had a caller call in recently, And, they couldn't sleep at night. They were stressed out. They had this one thing that happened 50 years ago, and they wanted to know how it's going to impact their life before they moved forward. And this is uprooting people who have been here, have built our country, and moved things forward, and they can't sleep at night. So if you are anxious, worried, concerned, you need to make sure you talk to an attorney to get the proper guidance. We're going to let you know, hey, are you in a bad spot? Yeah, you are. There's something we can do. There's always someone out there, those people who are desperate. We have, I think there's one company, they're just filing T visas um, just to try to keep them here, but that's not even a safeguard, and they can't even guarantee that ICE will not pick them up and detain them. So, that being said, let's hop into our topic for today. All right. All right. We're going to talk about harboring because this is one of the next areas that our administration is looking to. And they're addressing it towards employers, which is very important. They've threatened foreign nationals and even U.S. citizens. Now they're going to be focused on U.S. employers. Now, do they have the bandwidth to follow up on hundreds of thousands of employers in the U.S.? Absolutely not. But that doesn't, um, diminish the concerns and fears that we have and the precautions that you should take when you are an employer. Okay. So, here is what we're talking about when we talk about harboring. You know, whether you're an employer, a landlord, friend, or someone simply trying to help, there is a fine line between compassion and criminal liability under the U.S. immigration law. Today, we're going to explore what harboring actually means, how courts interpret it, and see what real life cases can teach us about the risks that are out there. So let's talk about harboring. What is it? Now, for those who are not familiar, harboring, there's a civil side of harboring, and then there is a criminal side. We're going to be focusing on the criminal side today. I do have an example in LA where we see some of the civil side and criminal. And another story we'll talk about that happened in 2018 for an individual, and that person was acquitted, which is a good thing. So the statute, the federal law statutes under 8 USC section 1324, and it states as follows. It is a federal crime to knowingly conceal, harbor, or shield from detection any person who is unlawfully present in the U.S. Okay, let me repeat that again. It is a federal crime to knowingly conceal, harbor, or shield from detection any person who is unlawfully present in the U.S. Now, the law applies not just to smugglers at the border, but to everyday people. Harboring can carry severe penalties. Those penalties include fines up to 10 years in prison, and even more if it involves profit or possesses a risk of life. But here's the question. What does it mean by harbor? What does it mean to harbor someone? It's very vague and it gets very complicated. And I think that's what we're seeing in the courts right now. It's not well defined. And because of that, it's very challenging. A lot of people will throw the word harboring out there, but what does it mean? Under federal law, um, so the law may be vague, but your options don't have to. Call us today, get clear guidance, and get peace of mind for you and your company to make sure you're protected. Landscaping companies, golf courses, all of you guys out there, construction companies, you need to do this now. You can lose everything under this statute. You could go to jail under this statute. And the administration is looking to utilize this statute to go after anyone or everyone they feel they can. Now, obviously, as I mentioned at the top, They can't go after 100,000 companies, but you don't need to take that risk. So, what's the difference between helping and harboring? Okay, so here's that gray line. Um, Helping someone, for example, giving them a ride, offering food, providing a place to sleep, can feel like an act of kindness. That's what many of us do. But depending on the circumstances, that kindness could be interpreted as harboring. The courts really have wrestled with this quite a bit. The 11th Circuit has said that harboring must involve actions that substantially facilitate someone's continued illegal presence and help them avoid detection. Whereas the Ninth Circuit um, takes a narrow view, and it has ruled that simply allowing someone to stay in your home isn't harboring. Um, and because there's no intent to conceal, you're just letting them stay at your home. And the interesting thing is, for example, it doesn't really matter. Let's say someone's illegal here and your spouse is a US citizen or a green card holder or illegal. Doesn't matter. If they're in your house and is that harboring your spouse who's here illegally? These are the gray areas. And these gray areas, as you can see in other aspects of what's happening in today's society and our use of social media, this gray area is causing so much stress and turmoil. The mere accusations of this is devastating to the everyday person. So please, please, please talk. You want to make sure that you understand this and that you're protected. So the distinction can determine whether you're acting morally or breaking the law. Now, you don't have to navigate this confusing area of the law alone. Contact our office now and let us help you understand the risk and defend your rights. We can't defend you when it's too late. When you're already in detention, it gets more expensive. It's going to be expensive anyways. You need to take action now to defend your to defend your rights. Let's look at a real world case. So here's an LA restaurant. So back in 2024, a Los Angeles restaurant owner was convicted of harboring unauthorized workers. In this case, the restaurant not only hired undocumented immigrants, but also provided them housing, paid them under the table, which of course those are all violations. And ICE agents found bunk beds behind the restaurant kitchen and falsified payroll records. Not good. In this case, the prosecutor argued that the employer didn't hire unauthorized workers. They concealed their presence, kept them off the books, and intentionally avoided detection. This case illustrates how employment, housing, and payment practices can combine into criminal exposure. Remember that we're not just talking civil impact, we're talking criminal. This is to the employer, the owner. Okay? Cases like this shows us how quickly routine business practices can cross into federal crimes. Don't wait until ICE is knocking on your door to call. Call our firm and let us review your policies and protect your business. All too often, the justification people have for this is, I can't find U.S. workers, or young kids like my kids don't want to work in a restaurant or work in the fields. There was another article or issue with an agriculture company that just got fined $400,000 for not paying their employees and other miscellaneous things. So for employers, it is critical. Please, please, please listen. Talk to your immigration counsel. If you don't have a good one that's going to talk to you, reach out to us today. We are here to help to make sure we protect your business so that you continue to do business and continue to make money well into the future. Now, one of the articles I want to jump in, and Jen, you can put this on the screen. Just one moment. Yeah, this was regarding a major agricultural employer under the H-2A. And there's 4 points that I just wanted to highlight. This is the one that got fined for $427,000 for back wages and other penalties. So what they found, the employer was ordered to one, they had to pay the correct adverse wage rate to all workers hired under the H-2A program. Now, if you're not familiar with the H-2A program, the H-2A program is for temporary agricultural workers coming in for a period of time, usually under 1 year. So, for example, think farmers who need extra workers to harvest and things like that. Additionally, the employer was ordered to provide employees with transportation and housing that meets all safety and health requirements, and only allow authorized drivers to operate vehicles transporting workers. Now, if you're not familiar with the H-2A, it also requires the employer to provide housing, transportation, and other benefits to the employee. Many of these farmers or agricultural employers just ignore that. And this is the result of ignoring. It's very expensive and probably will put them out of business. Next, they had to provide a copy of the H-2A contract to all workers. That includes detailed job description and duties. Very key. The laws that we have on the books are sufficient. It's just having someone monitor and follow up is the problem. All too often, we think immigration is the problem, and that's not true. It's really the implementation and the management of that system that's a problem. You can have any immigration system you want, but if it's not managed properly, if there's not procedures, oversight, it's not going to work anyway. So that's key. And we can see not only was the government not overseeing and working on this H-2A program, visa category, it still hasn't. And finally, the owner or the company has to train managers, human resource personnel, payroll personnel, and supervisors who are directly responsible for administration and management of the H-2A program. So those are the 4 bullet points that the court ordered. In addition to the 400,000 plus they had to pay back. And in addition to that, they can't use the H-2A program anymore. So now how are they going to get their employees? It's a mess. It's a mess. Now, most attorneys will say, hey, just close that company, set up a new company, and apply under the new company. Again, it's not necessarily the visa that's the problem. It's the management, oversight, and implementation of that visa category that needs to be changed. All right. A few more minutes. I know we're over. There's just so much good stuff to talk about. Next, humanitarian dilemma. Okay. But what about churches? Let's say, for example, are churches, shelters, friends? If an unauthorized or illegal person goes to a shelter or church, is that harboring? This is where things get tricky and controversial. Do we bar illegal people from going to churches? What do you think? Give me your thoughts in the comments below. You know, is that harboring? If you have an illegal person, do we put signs? No illegal people, can come into the church. Is them coming in for worship services or to a hospital or to schools or wherever? All the kids who may be here illegally, are the schools harboring? The Supreme Court has to define this and make it very clear. Otherwise, this broad, vague definition can be, placed on pretty much anybody. Even immigration attorneys, when we meet with clients, are we harboring them or giving them, preventing them from being detected? Or are we just doing our jobs and providing legal advice? So, in this case, in some communities, faith groups have offered sanctuary to immigrants. Under the Trump administration, there were high-profile standoffs between ICE and other around churches, housing, and undocumented families. Federal law doesn't exempt churches or volunteers, but prosecuting a nun for offering someone a place to sleep, that gets into the First Amendment territory. All right. Also the public perception. Do we want pastors and nuns and monks and other people being thrown into detention or put in jail for 10 years because they offered a place for a person to eat, sleep, or help them out. So this is very, very controversial and it's not clear. And as our government delves into harboring or using this as a reason to either compel employers not to hire foreign illegal people or to compel them um, to do whatever they want, this is going to be something people have to deal with. A good example of this is a really good article, and the outcome is very positive, even though back in 2018, Scott Warren, a volunteer with the No More Deaths, and in Spanish that's No Más Muertes, in Arizona, was charged with harboring for, what did he do? Did he keep him in his house? Nope. Did he, try to help people avoid, CBP or immigration? No. What he was found guilty of was leaving water in the desert and sheltering two migrants. And for that, he faced up to 20 years in prison, but was ultimately acquitted, thankfully. Um, so here, what was his defense? He wasn't trying to hide anybody. He wasn't trying to save. He was just trying to save lives, people crossing in the desert. This this case, you can read the articles. They're on the internet and get all the details. But there's a huge national debate of what's the difference between, helping someone, being humane, being humanitarian, as opposed to harboring. And I don't think we have a clear definition of that yet. Let's jump to employers so we can finish up today. I know we're going a little bit long, but this is a lot of great material. So for employers at the moment, hiring undocumented workers is already a violation of the immigration employment law. Don't do it. I know it seems tempting. I know there's not U.S. workers. You're going to have to find a way around that. The H-2B and the H-2A are not always very convenient or inexpensive. They cost a lot of money. You got to hire an attorney. You got to do recruitment. All this, it costs a lot of money to bring people over. And on the H-2A, you got to house them and pay for their transportation. All this becomes very costly. But with the price of everything going up, maybe we won't even notice. Now, hiring undocumented workers is always a violation of the immigration employment law, but if an employer also falsifies the I-9s, that's a violation. Pays under the table, that's a violation. Helps workers avoid detection, or provides housing or transportation while knowing someone is unauthorized, that is all very bad. That's when it becomes more criminal and just instead of a civil violation. What's scary for employers is that the intent can be inferred, okay? If you should have known someone wasn't authorized and you took steps to keep them on your staff anyways, that's a red flag. Prime example, you get a social security card. It looks suspect, but you're not using E-Verify, so you just say, hey, I got an employment authorization card. It may not be that person's. You're not sure. You need to properly verify and check things. But that's very common. It's getting false social security numbers where people create social security cards with other people's social security numbers. It's not just what you do, it's what you intended to do and what you knew when you did it. Okay, that's the key. Next, practical takeaways that we can take from this conversation. First, good faith matters, but it is not a defense. Okay, if you're knowingly helping someone evade detection, you're at risk. Intent is everything, people. Everything, folks. Are you trying to help someone survive or helping them stay hidden? Employers must follow the rules at the end of the day. You just got to follow the rules. Ways to do that is use E-Verify, document everything, and please do not cut corners. That's where people get into trouble. All right, guys. So let's be honest. Immigration is personal. It's emotional. People don't always fit into legal boxes, and sometimes doing the right thing might clash with doing the legal thing. but the law is the law. And this administration is utilizing that law in a way that may hurt your business, your family, your future, and your employees. So follow the law. Talk to our firm, call us for guidance so that you know that what you're doing is going to be protected. Now, crossing the line, even unintentionally, can come with some life shattering consequences. So be informed, be careful, get legal advice before getting involved. Thanks for listening for today. If you found this episode helpful, please share it with a friend. And don't forget to hit the like button if you're on YouTube, and follow us more on more things. As I mentioned, everything is changing weekly. Until next time, stay educated, stay informed, and stay on the right immigration path. Thanks for watching.